I don't mind trying to set it up beforehand, but honestly, I just started a new job and things like that. As long as it's far enough for me to actually be able to make it, I would like to show my best appearance and be a part of these things. I don't mind. I just haven't had the chance.
What do you want me to do?
Judge, anything that you find worthy. I appreciate being able to show up Zoom. But if the problem is me being here by Zoom, I will try my hardest to make it there. I just don't want to get in trouble because I couldn't make it there.
Mr. Brown, where are you at?
Pardon me?
What do you want me to do? I don't understand what you want me to do, ma'am.
Brown King on behalf of Mr. Barnes, Your Honor.
What are we doing?
I'm requesting adjournment.
May I say something, please?
Well, we're in court.
Can you what?
She wanted to
May I
talk to
say
me,
something,
but
please? No, I mean to the judge, to everyone. May I say something?
Go for it.
I would just like to say that I feel quite a bit of confliction here. I am still not very clear on why I'm even in court, and my attorney keeps getting changed, and it keeps getting adjourned, and no one's in communication.
Ma'am, I'm going to stop you. If you're worried about the attorneys getting changed and communications there, we can solve that problem by having you come down. I'll hold your file today, and then you'll be able to get a clear understanding from me directly as to what you're charged with. I don't mind going through an arraignment again, and then you can talk in detail with Mr. Brown if that's what you'd like to do.
I just would like for someone to be able to reach a little bit more out to me. I'm struggling with my transportation right now. I don't have the means for Uber, and my living situation isn't the best. I'm in a hotel, and I'm just trying to make sure I'm as clear as possible with everything that's going on is all.
Okay, I understand your concern, and I'm sure that the Public Defender's Office does everything they can to communicate with you. It sometimes can be difficult when the client doesn't appear here and is requesting to appear via Zoom, because even the conversation on this day can't happen. So if what you'd like me to do, given the adjournment, is set it the next hearing, if you don't believe that there's communication, I'll make sure the two of you get together, because I'll demand that it be in person and you'll have to be here. If that's what you'd like me to do, I'll be more than happy to do that.
I don't mind trying to set it up beforehand, but honestly, I just started a new job and things like that. As long as it's far enough for me to actually be able to make it, I would like to show my best appearance and be a part of these things. I don't mind. I just haven't had the chance.
What do you want me to do?
Judge, anything that you find worthy. I appreciate being able to show up Zoom. But if the problem is me being here by Zoom, I will try my hardest to make it there. I just don't want to get in trouble because I couldn't make it there.
Mr. Brown, where are you at?
pardon me?
What do you want me to do? I don't understand what you want me to do, ma'am.
I'm requesting adjournment on her behalf, but I'll be here till 4 o'clock. She wants to come on down. I'll be happy to talk to her.
You hear that, ma'am?
Yes, I do.
Mr. Brown is very dedicated. He'll be here till 4 o'clock. All right. So if you want, if you're worried about communication and something, he will make himself available.
Okay, thank you.
Right. So you coming?
I will try my hardest. If I'll call the prosecutor's office to get your information so that I can contact you.
How about we just adjourn it and we set a meeting where you come to my office?
That would be the best.
No, she should come down here by 4. You'll be here.
Oh, okay.
I can't guarantee that I can be there by 4. I have to get my daughter from the bus stop at 4:17 exactly. And I have to figure out if anyone can give me a ride out that way first. I don't have a vehicle.
All right, I'm going to let you guys work it out.
I'm just requesting adjournment, John. That's all.
Probable cause conference will be adjourned. I'll give you guys time to try to work this out. October 9th, 2025, 9 a.m.
You want my number again?
Yes, please. I do not have it.
222-6970.
Okay.
Okay, I'm on it.
Thank you.
All right. Bond will continue.
Okay.
Let's call the case. People versus Christopher Griggs.
Morning, Your Honor. Raymond Cook to the people.
We're ready in this man.
Ron Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Griggs. Mr. Griggs, please state your name for the record.
Christopher Griggs. Thank you.
Your Honor, today is the date and time set for the probable cause conference. We are respectfully requesting that this matter be set for preliminary examination.
All discovery is complete.
To the best of our knowledge.
People have their witnesses available the 30th.
We'll do our best, Your Honor.
Preliminary examination in person will be set September 30th, 2025 at
9 a.m.
at 9 a.m. before Judge Washington.
Very briefly address the issue of bond.
Very briefly.
Thank you. Your Honor, my client has a home in the area in which he could stay. The facts of this case is he's charged with CCW. He was driving a vehicle. That vehicle was pulled over for issues. Was not his vehicle. The owner of the vehicle was sitting in the car next to him. There were weapons found that were not in plain view. And he was subsequently charged merely for being present at the same place the weapons were eventually found. We're asking that, as we do not feel that the likelihood of conviction is very strong in this case, that his bond reflect that. He will return to all future court dates. He will abide by any strictures that the court place upon him. He's asking that he be allowed a personal recognizance bond in this case.
Your Honor, I do know the defendant does have some criminal history, as the court can see. So the charging documents, one of them was it was possession of a short barreled rifle or shotgun. The convictions are relatively old. The most recent one I see is from 2018 for an OWI third. As defense counsel indicates, the weapon that was found in the vehicle, which the vehicle is not his, but the weapon was found in the center console and he's driving it. The other passenger also indicates it was not hers. And so there is some concern whether the strength of that case and the likelihood of conviction, that's obviously up for a potential jury to determine at that time. But I just have some concerns given the prior history. I'll leave it at that.
So, Your Honor, to respond to what he said, the passenger was the owner of the vehicle. When they stopped it, my client was very calm, very cooperative. It was the passenger who owned the vehicle who was behaving in a nervous and strange manner. Again, there's nothing that connects. Well, we don't want to get too far in the weeds on this, but essentially, I do not believe that the prosecution is going to be very successful in going forward on this case. So I'm asking that a bond reflect that.
Bond is actually, quite frankly, for a weapons charge, very low at 5,000 cash security. So it's at a $5,000 bond. I don't think that is an abuse of discretion. I'm not going to change it. As bond, most for bond reduction is denied. Bond will continue. Certainly we can bring it up at whatever. Court does call the case of the people versus Crystal Barnes.
Assistant Public Defender Chelsea Rigios with and on behalf of Crystal Barnes, who appears via Zoom. Ms. Barnes, please state your name.
Crystal Denise Barnes.
Your Honor, we're asking to adjourn. I've spoken to prosecution about how I'm requesting some additional discovery.
Any objections?
No objection.
Did Mr. Brown sort of grant you with his grace of not having to get me a green sheet because of age?
I thought I turned in the green sheet. I'm sorry.
No,
I will fill one out immediately. I apologize.
that's okay. Ms. Vigils, you are always very good at that. I am blaming this solely on Mr. Brown.
That's right. She asked
Because I know that it's his fault. Probable cause conference will be adjourned to October 9th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Thank you.
The baby.
Court calls the case people versus, is it Jakeeb's Gully?
We're ready now. Deputy Chief Public Defender Attorney Ribbon on behalf of Mr. Gov.
Your name, sir?
Stevie is good.
First name is, say it again.
Don't worry about it. You ain't gonna get it.
You said I'm not gonna get it? I'm gonna call him Joe then. I'm not even, go ahead. What are we doing?
Your Honor, in this matter, we are respectfully requesting this matter be set for a preliminary examination
All right. Discovery is complete to your knowledge.
to the best of our.
All right. Well, other witnesses available the 30th.
We'll do our best.
Preliminary examination in person, September 30th, 2025 at noon. That's before me. Oh, no, I gotta try to say his name again, but he won't even give it to you. That's all right. All right. Bond will continue. All right. Thank you. Thank you, sir. Court does call the case of the people versus Michael Boyce Smith.
Brian Boyce Smith, Judge. State your name for the record.
Michael Boyce Smith.
Your Honor, I'm asking this matter be set for a preliminary examination. I believe all discovery to be complete.
People have their witnesses available the 30th. Preliminary examination in person will be set September 30th, 2025, 9 a.m. That's before Judge Washington.
Thank you, Your Honor.
Bond continued. Thank you. Court calls the case of the people versus Andrew Harrison.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Harrison, who approaches. Can you please state your name for the record?
Andrew Marquise Harrison. Thank you.
And Your Honor, we are just asking to set for a preliminary examination today. My understanding is that all the discovery is complete.
And Your Honor, for the record, we made an offer to defendant through the counsel. This defendant has 2 misdemeanors in 15th District Court as well. So the offer would be to plead to GBH strangulation, which is count 1 in this case, as well as the domestic violence and stalking he has against the same victim in the 15th District Court. That offer has been rejected and we're ready to
That is our understanding of the offer, Your Honor. He's going to give you a date right now. And my client is rejecting that at this time.
Preliminary examination in person will be set. People would have their witnesses available the 30th. The 30th.
I believe so, Your Honor.
All right. September 30th, 2025
Okay. Yep.
at noon. That's before me.
Thank you, Your Honor.
Bond will continue. Court does call the case people versus Latasia Brock.
Good morning, Your Honor. Raymond Cook for the people.
Under Hannah Apple, on behalf of Ms. Brock, who's attorney to Zoom. Ms. Brock, will you state your name for the record? Yep, she's there.
Ms. Brock, can you, oh, there she is. Can you state your name, please? Okay, I've seen her.
There she is.
Okay.
Thank you. Your Honor,
And we're just gonna shut your video real quick so that
can you hear
in case we have to ask you something, we'll hear you. Go ahead.
Your Honor, we're asking for an adjournment. We did receive the discovery, but however, we're asking for some additional time to review the video with my client.
All right. Without objection, probable cause conference, October 9th, 2025, 9 a.m. Bond continue.
Thank you.
Let's call the case people versus Marcus Jackson.
Good morning again, Your Honor. Assistant Public Defender Davey Leva on behalf of Mr. Jackson, who approaches from my right.
Jennifer Douglas for the people.
Your name?
Marcus Jackson.
Thank you.
And Your Honor, we are requesting adjournment today. I've provided a green sheet to the clerk, and I would be asking to address bond.
Probable cause conference will be adjourned September 30th, 2025, 9 a.m. as to bond.
Thank you, Your Honor.
Mr. Jackson is currently being held in a $500,000 cash or surety bond. We would ask the court to consider a lower bond or perhaps even a personal bond with a home confinement tether. He does have a full-time job at Primoris Renewable Energy, and he's very concerned that job will be lost if he remains in custody. He does have a place to stay in Dundee at an address that I can provide to the court. And again, we have no objection to a home confinement tether with release for work. I do also want to note that he has ties to the community, including the support of his fiance who is present here today.
Response.
Your Honor, we would object to a reduction in the bond. We believe that Mr. Jackson poses a danger and a flight risk. The reason that Mr. Jackson's bond is so high is based on some of these allegations. It's that police tried to effectively stop after seeing him run a red light. And that not only did he not stop, but that he fled at some point, drove in a circle around the police car, and continued to drive at a high rate of speed, doing U-turns, going into a parking lot, running multiple red lights, that he was driving in and out of oncoming traffic lanes, trying to evade the police, that he ended up intentionally driving headfirst into the vehicle of a police officer, disabling it with the crash, and continuing to drive, and while trying to get away, ended up hitting two other police cars. When the car finally stopped, when police had pinned him in, he said he was still fleeing on foot. He did have a passenger in the car. The passenger stayed there, said that did not know why Mr. Jackson had fled, and he was just a passenger. He spoke to police and cooperated with them. However, Mr. Jackson fled on foot. Police tried tasing him multiple times, and eventually had to just tackle him. He continued to try to get away from police once they had physical hold of him, Your Honor, and the police indicated that he smelled of alcohol. Now, Your Honor, he was recently arrested for OWI on August 17, 2025. Our office does have that warrant request, however, it's not yet been charged. And so, Your Honor, we do believe that there's a danger here in that him being arrested on August 17th for OWI, and then him being arrested this time with the driving that we saw and smelling of alcohol, and allegations of drinking and driving in this case. I'd also note that he does appear to come from Georgia. His license is from Georgia. And so we do think that there is a flight risk here based on that. And that is why we believe that the bond is appropriate as such.
I just want to make sure I heard that correctly. He went headlong into a police vehicle?
Yes, Your Honor. Front crash, disabling the vehicle, and that car is unable to operate.
You got anything else to say?
No, Your Honor.
Before I deny your request?
No, Your Honor, but I appreciate the
Motion for bond
consideration.
reduction is denied. Thank you. Bond will continue.
It should be apparent in the Bureau of Prisons. They tend to die. 507, the one that's unmuted.
Got it. Court does call the case of People versus a Johnny Wright.
Anjanae Wright.
Anjanae, I'm sorry. It's been a morning. We thought that was you that had dialed in. All right.
Good morning, Your Honor. Tina Saxon on behalf of Anjanae Wright.
All right. What are we doing on this?
Your Honor, I was just appointed yesterday and I have not even had a chance to speak to Ms. Wright. I'm asking for an adjournment.
You're in the Bureau of Prisons, correct, Ms. Wright?
Yes, I am.
In Minnesota, Your Honor, so I'm also trying to get on the list so that we can have a conversation or video visit.
What I'll do is I'll adjourn the probable cause to October 23rd, 2025, 9 a.m. Bond continue.
Thank you, Your Honor. Have a great day.
Thank you. Thank you, Ms. Wright.
Thank you.
Court does call the case
Sorry.
Yeah, good. Court does call the case People versus Marvis Jones.
Assistant Public Defender Jay Bellinger on behalf of Mr. Jones, Your Honor. Mr. Jones, can you please state your name for the record?
Marvis Keaton Jones.
And Your Honor, we are just asking to set these for preliminary examination today. It doesn't look like we're getting an offer on these.
Pardon? Doesn't look like.
It doesn't look like there's an offer at this time on these cases, Your Honor,
And discovery is complete here.
to the best of our knowledge, Your Honor.
People have their witnesses available the 30th.
Do our best, Your Honor.
Preliminary examination in these matters will be set for September 30th, 2025, 9 a.m. before Judge Washington.
And Your Honor, if I may briefly address bond.
Man,
Your Honor, my client is currently on parole. He advises that he can live in parole housing in Toledo, where he would be supervised by parole. During my understanding is that these cases are 5 to 6 years old. They're not violent offenses that are being alleged here. In 2020, when he didn't, I understand that the warrants have been out on these for quite some time, obviously. In 2020, at the time that the warrants were issued, my client lost his daughter, unfortunately, due to gun violence. That took precedent in his life at the time over these. My client understands the serious nature of these cases and is willing to obviously appear for them. I understand he's in custody right now, but he does assure the court that he would be willing to appear. Like I said, he has supervision in Toledo where he can stay in parole housing. So we would just be asking for his release at this time.
response.
Your Honor, defendant was on bench warrant status for multiple years and never turned himself in. I like concern the risk, especially if it sounds like he's going to be residing out of state. I have further concerns that he's not going to return back. Going to just let these go into bench warrant status again. I'd ask the motion to be denied.
And Your Honor, if I may briefly respond to that, my client was in prison at the time that this happened as well. So there was not much of an option for him to address these. He did attempt to do that so that he could see about getting time served on these at the time, but he was unable to do so.
This time there are 3 cases. Preliminary examination before Judge Washington. So on the 30th, given everything, the court is going to decline to reduce his bond at this time. Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Yeah, you did.
False case of the people versus Maurice Burgess.
People.
Assistant Public Defender Jay Bellinger, on behalf of, but not with Mr. Burgeons. Your Honor, we have just spoken to Mr. Burgeons' wife about 20 minutes ago. My understanding is that he's on his way to court. I understand that there's also.
Where is he?
Your Honor, I did.
Got some real problems.
Your Honor,
and I want him here now.
Your Honor, I do understand that as well. If the court would be willing to pass this case to the next.
Absolutely.
Thank you.
I want him here in the next 5 minutes.
I will do my best, Your Honor.
I'm taking him or you. See how many different. What, everybody's trying to hold him up now, so take him. Melissa Konwinski.
Assistant Public Defender Chelsea Vergils with and on behalf of Melissa Konwinski. Ms. Konwinski, please state your name.
My name is Melissa Marie Konwinski.
Can you sign here to waive the preliminary exam?
What are we doing?
Your Honor, my client is currently signing a preliminary exam waiver form, so we would ask to waive that and get up to circuit court. I would also ask to address bond.
Ma'am, you're waiving your right to a preliminary examination.
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further
Yes, Your Honor.
resolution. People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
We acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant able to formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for
September 30th at 1:30 with Judge Cummings.
September 30th, 2025, 1:30 before Judge Cummings. As to bond.
Your Honor, we are asking for release on a personal bond with a scram tether, or if the court is not willing to consider that today, we're asking to set a cash bond because I believe her bond is currently denied. And I believe her current actions while in custody and her plan for being out of custody demonstrate her commitment to her sobriety. So in custody now, she is going to church, she's going to AA, she's enrolled in Dawn Farm. She has been also taking mental health classes. Her plan for when she gets out of custody is continue with the AA, of course, with her fellow Bear River alumni and to do intensive outpatient with Trinity Health. We do actually have printed out her email confirmation that she has an appointment on September 22nd. Very much like to be at that appointment and get going with her intensive outpatient treatment. Again, coupled with the AA classes, her continued mental health treatment with CMH, I think that she has compiled a great plan to hopefully have success with her sobriety.
Response.
I think the court recalls,
I do.
thank you, Ms. Tomlinski, and the concern of the people, it's multiple, but on an OWI with BAC of a 0.28 with a crash that she fled the scene from and 2 priors from 2021, and then drinking while on bond, I have significant concerns, which are not alleviated by the then lying about it being mouthwash and about, sort of making excuses for herself. Glad to hear things have changed. Glad to hear things are getting better in jail. But if the court is going to consider any release, I would request that it be with a scram charge.
At this point, given everything, I understand the plan. I understand where she's headed. However, she was basically almost a 0.3. She gets a PR bond with a release to tell her not to drink, and she just can't do it. Even though that's there, I think there's going to have to be a little bit more structure from my standpoint before I would release her. So at this point, your motion for bond reduction is denied, and her bond will continue as denied.
Okay.
Court does call the case of People versus Nicholas Chalmers.
Assistant Public Defender Chelsea Vergil is on behalf of Nicholas Chalmers, who appears via Zoom. Please state your name.
Nicholas Chalmers.
Thank you, sir.
We are asking to adjourn for additional discovery. Does the court happen to have a green sheet?
I do.
Awesome.
Without objection, probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the People versus Dion Richmond.
Andrew Baptist. Ready, Your Honor. Assistant Public Defender Jay Bellinger on behalf of Mr. Richmond. Mr. Richmond, can you please state your name for the record?
D.R. Richmond.
Thank you.
And Your Honor, we are asking to set this matter for preliminary examination at this time.
Discovery complete.
To the best of my knowledge, Your Honor, I also understand that there is a tentative offer. I have not been able to go over that with Mr. Richmond. However, I'm still working out the details of that. If we are able to resolve prior to preliminary examination, we certainly will.
People have their witnesses available the 30th.
I believe so, Your Honor.
Preliminary examination in person, September 30th. 2025, 9 a.m. That's at noon. At noon, that is before me.
Thank you, Your Honor.
On continued. Court does call the case People versus LaShawn Charles.
Assistant Public Defender Jay Bellinger on behalf of Ms. Charles, who appears via Zoom. Ms. Charles, can you please state your name for the record?
LaShawn Charles.
Say your name again, please.
LaShawn Charles.
Thank you.
And Your
You're
Honor,
welcome.
I am just asking for an adjournment on this matter. I am still trying to work out some sort of resolution for Ms. Charles at this time, so I'm just asking for 2 to 3 weeks.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond continues.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, ma'am. Court does call the case of the people versus Javier Ruda. Javier Ruda, and don't you this?
Bring to the people.
Ron Brown appearing on behalf of Mr. Ruder. Sir, can you introduce yourself?
Javier Rueda Noguera.
We'd ask the court to set this down for preliminary examination. See if the witness can show up.
Discovery is complete.
To my knowledge, Your Honor.
People have their witnesses available the 30th.
We'll do our best.
Preliminary examination will be set September 30th, 2025, 9 a.m. before Judge Washington. Bond continued. Court calls case people versus Tristan Clay Radcliffe.
Morning, Your Honor. Bring to the people.
And Assistant Public Defender Jay Ballinger on behalf of Mr. Clay Radcliffe. You say your name for the record, Tristan Clay Radcliffe. And Your Honor, I am asking for an adjournment on this matter. We just need to confirm that restitution was paid in full before discussing an offer on this. My client advises that he paid restitution in full in January, so we did give that information over the prosecution. So just a couple weeks so we can see.
But not to the court. So it's not something the court could track. He paid it.
Correct. He paid that way back in January, Your Honor.
To the court?
Not to the court, Your Honor.
Not to the court.
Correct.
And that's accurate, Your Honor. I just received that documentation from opposing counsel this morning, so I just need to confirm with the victim to make sure that that was paid.
Probable cause conference will be adjourned September 30th, 2025, 9 a.m. Bond continued.
Your Honor, I did supply the court with a stipulated order for amended bond for my client.
I know.
Oh, okay. I'm sorry. Is that something that the court is willing to sign? Maybe you said something and I didn't hear you. I
Is
apologize.
your other client here yet?
I'm working on it, Your Honor. Diligently.
So he wants me to do something here, and I asked him to do a little thing again, and he won't do that. So I probably shouldn't sign his order.
Oh, well, that has nothing to do with this guy.
This guy being your client?
Correct.
Okay, you're right. I've already signed.
Thank you very much, Your Honor. Thank you. Thank you, Your Honor.
Did you see what he has nothing to do with this guy? Court calls the case people versus Jeremiah Sawyer.
And for the people.
Brother Judge. Court will be to Assistant Public Defender on behalf of Mr. Sawyer, who is approaching the podium. Mr. Sawyer, when you get here, please state your name for the record.
Jeremiah Sawyer. Thank you, sir.
Thank you, Judge. I have reached out to the people and I spoke with Mr. Sawyer. We are asking for a brief adjournment to continue negotiations.
Probable cause conference will be set September 30th, 2025.
Thank you very much, Judge.
And bond continue.
We'll be in touch.
Thank you.
September 30th.
Court does call the case people versus Wanalan Cleaver.
Morning, Your Honor. Bring to the people.
Good morning again, Your Honor. Assistant Public Defender Deputy Lebo for Mr. Jake Quellen Cleaver.
Your name?
Quellen Cleaver.
Got it.
And Your Honor, we are requesting an adjournment of about 3 weeks, and I have provided a green sheet. Quellen?
It'll take you 3 weeks to review discovery.
We also would like to begin some negotiations, Your Honor.
Probable cause conference October 9th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case people versus D'Angelo Simmons. I gotta squeeze in.
Right, again, Judge. Court shall please to Assistant Public Defender on behalf of Mr. Simmons. Mr. Simmons, please state your name for the record.
D'Angelo Simmons.
Thank you, Judge. My understanding at the last court date, the competency was, he was found competent. We are still negotiating with the people to try to find a potential resolution on this matter. We'd ask for an adjournment.
Is this the only thing he's held on, or?
As far as I know, Your Honor.
Probable cause conference will be adjourned September 30th, 2025, 9 a.m. Bond continued.
Thank you, Judge. We'll be in touch.
Court does call the case People versus Deshaun Clifton.
This is public defender Hannah Apple appearing on behalf of Mr. Clifton, who's approaching now. Your Honor, Mr. Clifton has executed a preliminary exam waiver.
Say your name.
Yes.
Deshaun Clifton.
Thank you. You signed this examination waiver?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2 with 3 following.
Your Honor, we acknowledge receipt of the information. We'll stand mute, wait for more reading.
Defendant having waived formal reading, standing mute as to all 3 counts, court will enter a not guilty plea. Pretrial will be set for
November 10th at 1:30.
November 10th, 2025, 1:30 before Judge Hammoud.
Thank you, Your Honor.
Your Honor, if I may also place on the record, that waiver was made. There is an offer that he would plead to count 1, count 2, and 3 would be dismissed. There was discussion of adding a count 4 for reckless driving that will not be added based on the waiver.
And that's correct, Your Honor.
All right, very good. Bond will continue.
Thank you.
Thank you. Court calls the case of the People versus Bosie Smith.
Good morning, Your Honor. Marie Cannon, Assistant Prosecuting Attorney on behalf of the people.
And good morning, Your Honor. Sydney Rushing, P78820, appearing on behalf of Mr. Smith, who's approaching the podium. Mr. Smith, can you state your name for the record?
Boise Smith. Thank you.
Your Honor, we have not received discovery yet in this matter. I did request it. I received a response asking for the signed order of my appointment. I did say that I had the one that was submitted to the court along with Ms. Wheatling's response saying that it was signed, and then they left me on red, Judge. So they didn't want to send me the discovery prior to.
Wow. That was really accusatory. Is that what they
I
did?
received a response. So that's what I think happened. They left me on red.
Okay, so just knowing how this is going to work, I'm sure we have a response from Ms. Tana. Go.
Thanks, Your Honor. Ms. Rushing, if you want to send it directly to me, I'll make sure it's taken care of. I'm not aware of what happened or who left you on red. It certainly wasn't me personally. I would never do such a thing. And Ms. Rushing, there is something important I do need to discuss with you regarding this case that I forgot to put on the record. So if you could email me or get in touch with me somehow as soon as possible, I'd appreciate it. Your Honor, there's also an additional matter. This defendant making calls to the victim's number, the number that is listed in the police report from other ends since he was arraigned. At the time that we looked into this, there were 7 calls made. The concerning part is in addition to the calls being made against his bond conditions and the privilege of being in the situation he is, the calls are concerning because he is having people instruct her essentially as to what she needs to do and not do and so on. I haven't listened to them personally. I will do so. I'll make sure that Ms. Rushing gets those calls so that we can discuss it further. However, at this point, based on what we do have, I'd ask for his phone privileges to be removed.
Your Honor, if I may.
Yes.
I would ask that you consider putting this over for 1 week and before you're granting that request. I think I heard the people say that they haven't heard them personally yet either. So that means neither her or I have heard them to confirm what was said or what wasn't said. So I'd ask if you would consider just holding that order or motion in abeyance for 1 week for me to review them. That is my only request. Thank you, Judge.
And potentially have your client make additional calls to the victim, now knowing that they're on to it. I'm not going to do that. Defendant's phone privileges are hereby ordered revoked pending a hearing. And if you want a hearing on that, I'll be more than happy to set that up for you. Probable cause conference in this case, if you wanted to adjourn a week, I'll give you a week. I'll set it for September 25th, 2025, 9 a.m.
Thank you so much, Your Honor. I greatly appreciate it.
Thank you, Bond.
Have a great day to you and your wonderful staff.
You do the same. And I called your case, didn't leave you on red, right?
You didn't, Judge. I really appreciate that. You always make sure I'm taken care of. I appreciate it.
Thank you.
Have a great day, Judge.
Too. Court does call the case of the people versus Danina Combs.
Brown
Josh Feltus for the people.
Brown appearing on behalf of Ms. Combs, Your Honor. I was going to request an adjournment.
I'm sure you were.
I got your
In
green,
light of the violation,
got your green paper.
like Bellinger. I know, you,
Should I file it?
I'm here.
you can file it. I'm not, is she here?
Yes.
What's your name?
Danina Combs.
She's got a violation, so she's gonna need to appear personally.
You hear the judge? You got to come down. He wants to see you.
Your Honor, I got into a bad car accident and my back spine is broken in 2 spots. I can't.
Are
even
you in the
walk.
hospital?
I just got out.
Okay, so here's what I'm gonna
Day
do.
before
I'm gonna
yesterday.
set this for 3
But-
o'clock, giving you an opportunity, or for 2 o'clock. Giving you an opportunity to send to Mr. Brown, who's apparently gonna be here till 4. To
Yeah,
send to
I
Mr.
got out.
Brown detailed information regarding that. Otherwise, I will expect you here.
Okay. I have the paperwork.
Okay, get that to Mr. Brown so he can let me know.
Okay.
Thank you.
Thank you.
Court does call the case People versus Matthew Verveal. Mr. Bellinger, do you have your client yet, or do I need to send my people?
Your Honor, he is on a bus.
Okay, we'll talk.
And Your Honor, good afternoon. Good morning. Since Alexander W. Leba with and on behalf of Mr. Verville. Mr. Verville, can you state your name?
Matthew Verveal. Thank you.
And Your Honor, we are requesting an adjournment today, and I have provided a green sheet to the prosecutor. I'm sorry, to the clerk.
The is that you guys doing investigation that's gonna take a minute, or what?
Your Honor, so this is a matter involving a child abuse allegation. We've requested the CPS report. So it's going to depend on how quickly they will provide that to us.
Probable cause conference will be adjourned September 30th, 2025. 9 p.m. bond continued.
Thank you, Your Honor.
Yes.
I have some additional.
Oh, okay, go ahead.
There is going to be a child advocacy center interview in this case, hasn't been scheduled yet.
Got it.
You maybe have an additional week just to ensure that.
That's fine. You have any objection to that?
I have no objection to that, Your
Okay,
Honor.
I was setting it that way so that, because he was in custody, but my next date would be October 9th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls case People versus Rachel Corser.
Andrew Banish for the people.
Assistant Public Defender Chelsea Ridgeels with and on behalf of Rachel Corser, who appears via Zoom. Ms. Corser, please unmute and state your name.
Rachel Ann Corser.
Thank you.
Your Honor, we're asking to adjourn. There's very recently been an offer that I'm asking for time to discuss with Ms. Corser.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank
You don't want to address bond? No, I'm kidding. Go. I'm sorry. Court calls the case People versus Sean Beater.
Andrew Banish for the people.
Hello, your name?
Sean Vitter.
All right, what are we doing? Who's? Who's? She was here. Yeah, one case. One case. She was here. When I call it, she's not.
Truth.
Stephanie Cannon on behalf of Mr. Beater, who is standing to my right. Mr. Beater, could you please state your name for the record?
Sean Beater.
We made his finding.
We have not made it as of yet, Your Honor. I did provide the court with paperwork as it relates to a finding of competency.
It's has started. It's has.
Yeah, you did. You passed with finding?
Yes.
And so I did provide the prosecutor and this honorable court with that information, Your Honor.
Yes, and I have reviewed that. Is there any additional information either from the people or defendant?
Your Honor, we will stipulate to those findings. It is my understanding that paperwork for criminal responsibility has already been submitted. It's my belief and understanding is that.
I don't know about that.
September 4th, Your Honor, signed both the order for competency evaluation. It's now been found competent. People also stipulated to that. I have no further information on that. I saw in my file that you also signed an order for evaluation relative to criminal responsibility. I'm not sure if they're proceeding with that or not, but
I don't know if they are, but I wouldn't deal with it here. That will be dealt with at circuit court, so I'm not even addressing that. Having no other evidence as it regards competency, court upon review of that report would find that the defendant is competent to stay in trial, which finds specifically that he can understand the nature and objects of the proceedings against him and can rationally assist his defense. Therefore, the defendant is deemed competent. I do order, I have signed that. You would like this set for probably.
Yes, Your Honor. I need the opportunity to speak with my client. I did attempt to do so twice this week, but there were some things going on at the time. It appears that he's a little bit better now, so hopefully I'll be able to speak with him prior to the next hearing.
Would you like the 30th or October 9th?
Your Honor, the 30th is fine.
All right. Probable cause conference will be set October 30th, 2025, 9 a.m. Bond continued. Thank you.
Can you sign it for me?
I don't really want to give my information out there.
Okay, that's perfectly fine. You don't have to. Thank you.
Court does call the case People versus Dustin Duncan.
Andrew Bennett.
Brian Bowling on behalf of Mr. Duncan, who it's my understanding he's present on Zoom, Judge.
Yes, he is.
Yes.
And
can you state your name for the record, please, sir?
Dustin Wade Duncan.
he needs to be here.
Right, Judge. Mr. Duncan requested Zoom, which was approved, then revoked based on the Community Corrections report that was issued in this court issuing a
So
bench.
how soon can he be here?
So, Your Honor, he's at the University of Michigan Hospital for a medical procedure right now. It's up to the discretion of the court. I mean, I think he
I'll
could
set it
probably
at
do
3
there.
o'clock. He needs to get here.
Okay.
Otherwise, there's going to be a warrant.
Mr. Duncan, the judge is ordering you to appear here by 3 o'clock this afternoon, okay?
Okay, thank you, Your Honor.
Thank you.
Thanks, Judge.
Court calls the case People versus Jeffrey Williams. Let me get counsel. No.
This Mr. Williams?
It is.
It is.
Ron Pring on behalf of Jeffrey Williams. We sent over a form for him to be referred to the 15th.
What?
We sent a form over for the 15th mental health court.
I don't have any. When did you send that this morning?
Monday or Tuesday.
I'll sign off on it. I don't have a problem doing that, but I don't have it right with me right now. We'd have to sort it out anyway.
Yes.
Possession of the same gun that's charged in count 3. And they saw fit to give him a PR bond.
Well, that's the feds.
I'm just
not me.
I didn't say that, Judge. All I'm saying is that's a fact.
Well, they got a whole different way of doing stuff.
I don't disagree, Judge.
For bond reductions tonight, certainly you can bring it up at the next hearing this time, but it's bond will at this point will continue. Court calls the case of the people versus, is it Hatiam Al-Shalabi?
Court will on behalf of the people.
Well, Judge. Court shall cease to assistant public defender on behalf of my client. Please state your name for the record, sir.
Hatiam Al-Shalabi.
Thank you, Judge. I have had a chance to speak to my client and to the, with the prosecutor, still trying to find a resolution in this matter. We'd ask for a brief adjournment, Your Honor.
Hearing no objection, probable cause conference will be adjourned to October 9th, 2025.
Thank you very much, Judge.
Bond continue.
Thank you.
Thank you. Oh, okay. Let me do a couple. Why don't you? Take my word out. Oh, sure. Court does call the case of the people versus Sherry Walker.
Yes, Your Honor. Brandon Bird on behalf of Sherry Walker. Ms. Walker, can you please state your full name for the record?
Sherry Walker. I have before me a plea form. Is that what we're doing today?
Yes, Your Honor.
Plea form indicates that the defendant will be pleading guilty to an added count 2 of retail fraud in the second degree. That's a 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed, although the sentencing judge waiver is checked on this. This is a SK 14A1 case, so it would remain with me. That's the court's full understanding of the agreement.
That's fine.
Yes, Your Honor, that's correct.
May I have her sworn?
Right. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Sherry Walker. So Walker, it's this court's understanding that you're going to plead guilty to the charge of retail fraud in the second degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. Fine could be increased at 3 times the value of property taken. If that's greater than $2,000, that would become your maximum fine. You understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
To that charge, how do you plead?
Yes, sir.
How do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial? Be kind.
Yes, sir.
All right. You had signed an advice, have you signed an advice of rights form?
Yes, sir.
All right. Any question regarding any of those rights?
No, sir.
All right. You'll see a copy on the podium. Paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Somebody threatened you or coerced you?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Yes, sir.
On June 12, 2024, at the location of 3300 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, what did you do at Home Depot that makes you think that you're guilty?
I took some items that I didn't pay for.
All right. Tried to walk out of the store without paying for them?
Yes, sir.
Store was open to the public at the time?
Yes, sir.
You didn't have anybody's permission to take that property?
No, sir.
And this property you took was offered for sale?
Yes, sir.
And this is a second based upon value or prior?
That's based on value, Your Honor. It's initially a first, based on it being a subsequent, but.
Got it. Ma'am, was the items that you took, was the aggregate value of that in excess of $200?
I don't know exactly how much it was.
If I said it was $337.98, would you have a reason to dispute that?
No, sir.
All right. And so you'd stipulate or counsel agreed that that's the case?
Yes, Your Honor.
Yes, Your Honor.
All right. Ma'am, if I do accept your plea, if between the time of plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rule, you would not be entitled to any sentence, the court would not be bound by any sentence recommendation to it, and you would not be permitted to withdraw your plea. You understand that?
Yes, sir.
Is that a yes?
Yes. Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
I'm not, Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor. Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be
October 8th at 9 a.m.
October 8th, 2025, 9 a.m. That's before me. Bond will continue.
Thank you. Have a nice day.
Thank you. You do the same.
Thank you, Your Honor.
Everyone can remain seated. Court will stand in brief recess.
I'm asking for an adjournment. Ms. Tanha and I have discussed some possible discovery that might be outstanding, so we're hoping to get to the bottom of that. So we just need a date to come back.
Thank you. October 9th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Okay. Court calls case People versus Michael. Is it Gotchentower?
Brian Bowling on behalf of Mr. Guttenauer?
Gokenauer.
Gokenauer. Your Honor, I'm also seeking an adjournment in this matter so that Ms. Feltus and I can have some additional plea discussions related to this case. So there should be a green form in the file on this one as well. Then I'd like to address bond if I could when the court's prepared.
I'll adjourn this one to September 30th, 2025 at 9. Yes, that's the bond.
Thank you, Your Honor. The current bond in this case, to my understanding, is a $5,000 10% bond. Mr. Gokenauer lives in the city of Detroit, Your Honor, by himself. However, he does have a 9-month-old daughter with his significant other that he is active in that child's life. He works as a plumber. He has jobs scheduled and in progress here in Michigan that he would like to get back to. We'd ask the court to consider granting him a personal bond in this case.
Response.
Your Honor, I do have in my office requested a monetary component at the time of arraignment. I will note that the defendant does have a pretty significant multi-state history. So I wonder if that was a basis for setting the bond, if the magistrate did. And it does look like he completed a prison term for a larceny, 1,000 to 20,000 in April, and maybe completed a parole in April of 2025, but it could have been a prison term.
It was because of the relationship to this offense to parole that caused the monetary bond.
That makes sense, Your Honor. Thank you.
Anything additional?
No further.
Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor. Your Honor, I missed the date. I apologize.
The date is September 30th.
Thank you, Judge. Mike. Thank you, Your
Honor. Can you hold Ann needs to go bond. Court calls the case People versus Anitha Barnes.
Anitha Barnes.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And of your own free will?
Yes, I am.
All right. The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 259660. Any objection to the court having reviewed that report?
No objection.
No.
Upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Mr. Dingman, I'd have to advise you that if between the time of my acceptance of your plea and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled, the court would no longer be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, I understand.
You understand also you would not be entitled to withdraw your plea.
Okay, I understand.
Understand that? Okay. Counsel, are there any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, you're not.
And has the court complied with the court ruling? Would it be proper to accept this defendant's plea?
Defense is satisfied.
People are satisfied.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
October 8th at 9 a.m.
October 8th, 2025, 9 a.m. before me.
Your Honor, if I may address bond briefly on my client's behalf.
No, I was talking about that.
Thank you.
What happened this early, but go ahead.
Your Honor, I'm asking the court to consider a release on a personal bond. I did have a chance to meet with Mr. Dingman. This is the only matter holding him. He does have a cash bond on a 14B case that my understanding is to convert to a PR if this case is converted to a PR. It's $1,000, 10% right now. Mr. Dingman has been complying with the probate order. He's been receiving his medication. This is a 90-day misdemeanor he pled to, and he currently has 55 days credit for time served. Based on that, I would ask for consideration for, or if not, maybe after he completes his PSI in custody.
Response.
Your Honor, we would leave it up to the court's discretion. He is currently undergoing treatment.
All right. What I will do is I'll grant your request and deny your request in part. His bond will become a PR after he's in probation.
Understood.
All right.
Thank you. Thank you, Judge.
Thank you. In part. Court does call the case of the People versus Dalton Hall. We're ready then.
Good morning, Your Honor. Laura Willenberg on behalf of the people.
Good morning.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Hall, who approaches from my right. State your name for the record.
My name is Dalton Hall.
Thank you.
Your Honor, today is the date and time set for the probable cause conference. We just received some further information in this case. We would ask for a week adjournment so that we can process that and talk about options for my client. He needs to be informed of certain developments in this case.
All right. Just procedurally, as to he's not been arraigned on counts 5 and 6. I'll wait formal reading of those counts. And
yes, Your Honor.
He stands mute.
Yes, Your Honor.
Defendant having waived formal reading, standing mute as to those counts, court will enter a not guilty plea.
Thank you, Your Honor.
Any objection to the 1 week adjournment?
No, Your Honor. I will also at this time move to dismiss counts 1 and 2 as they were corrected by adding those amended counts.
Gotcha. Okay. So I will dismiss counts 1 and 2 in this case. No objection, I'm presuming this.
No objection. Thank you.
You want a 1 week adjournment?
Yes, please.
So do you feel at your age, you don't have to give me a green sheet? No, that's okay. It's all right. I don't need an answer to that. I'll wait.
Let me think. Okay. I got one for you. I get you one.
Probable cause conference in this case will be adjourned to the 25th.
All right. Thank you very much, Your Honor.
Continue. Court calls the case People versus Timothy Flood.
Ready, Your Honor.
Good morning, Your Honor. Joe Simon on behalf of Mr. Flood, station agent.
Timothy Flood.
And at Mr. Simon's age.
Ouch.
Got me this year.
Mr. Vincent and Mr. Goldstein and I were having that discussion, Your Honor, and
it is official that I cannot deny that age anymore. So I think I have to concede.
Very good.
In this case, Your Honor, I made a proposed resolution to Ms. Willenbring the other day that she's going to consider, we're asking the court to adjourn. Well, there's no commitments. I'm sure she's going to add that in a minute, but she's going to at least consider what I've offered.
All right. I can go to the 30th or the 9th.
The 9th, I'm traveling, Your Honor. And I don't know if just check the 30th real quick. I can do the 30th. Thank you.
Probable cause conference will be adjourned to September 30th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
All right, Tim, you can get out of here. All right, see you.
Court does call the case of the people versus Winona Harvey.
We're ready. So that'll be next. Lauren Brown, Deputy Chief Public Defender, came with and on behalf of Ms. Harvey, who approaches.
Can you state your name, ma'am?
I don't know my name.
You don't know your name?
No.
Okay.
I can't use my first last name and I was Bruno middle name.
Okay. All right.
My son, nothing.
What are we doing?
Your Honor, this matter is set for a competency review. We do not have an updated report. Does the court have an updated report?
I do not. I have not received a report.
And I believe it might be appropriate for us to wait to get an updated report.
You know my name?
Yes.
Winona Harvey.
Got it.
I'm appearing with and on behalf of Ms. Winona Harvey.
All right. Has anybody contacted the forensic center to see when a report might be forthcoming?
We've got no communication on that.
Ms. Lowe?
Yes, I've been really had contacted them prior, and initially they had said that the report would have been done by today, which is why we had it set.
Why we had it set for today. That's what I thought.
Still waiting.
All right. What I'll do is this. I'll adjourn the competency hearing to October 30th. We will move that date up if the report comes in pursuant to the statute. So October 30th, 2025, 9 a.m.
Thank you very much.
All right.
Okay.
Bond continue.
Thank you.
Let's call the case of People versus Jordan McKinney.
He was here earlier. You can look out in the hallway. David I. Goldstein, appearing on behalf of the defendant.
It'd take a while.
State your name, please.
Jordan McKinney.
Your Honor, I believe that the discovery has been provided. We're asking the matter be set for preliminary examination.
Yeah, for the record, I was prepared to make a very reasonable offer. It doesn't sound like we are in that table stage. So we'll move on. Thank you.
Well, I will consider that between now and the date of the exam. I'm considering the
That would
offer.
be very good. Thank you.
Okay.
Guys are done. Covering everything completed. Would the people have their witnesses? We're on the 30th.
Yes.
Sorry, what date, Your Honor? Sorry.
People have their witnesses available September 30th.
I believe so, Your Honor.
Preliminary examination in person will be set September 30th, 2025 at 9 a.m. before Judge Watt. Wilkins. That's called the case of People versus Justin Scott.
That's false for the people.
Right, Judge. Torshio Feaster, Assistant Public Defender on behalf of Mr. Scott, who's approaching the podium. Mr. Scott, please state your name for the record.
Justin Scott.
Thank you, Judge. I spoke to my client. I reached out to the people on this matter. We are still negotiating. I'd ask for a 2-week adjournment, please.
I have 1 and 3.
Oh,
well, I have the 30th.
Let's go to 3.
Pardon?
Let's do the 3, please, Judge.
The 9th.
Yes, Judge, because I'm going to ask you now for a release to treatment.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond will continue. If you send over the release treatment order, I will.
Thank you, Judge.
All right. Thank you. Thank you. Court calls the case of the People versus Christopher Coffey. Ms. Wiley, approach, please.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Coffey, who I have not been able to locate.
Okay.
Oh,
I'll talk to. Well,
Good morning.
good morning. Who was the prosecutor on this?
It's ring for people.
God, I hate to do this so early. Did you pull those?
I can wait.
I don't have them. Can I see counsel in back just momentarily? Court is standing in brief recess. Everybody.
Good night. Thank you very much.
What happened?
Ashley Feltus for the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Anthony Williams, who is in custody.
I have this as an AG case.
I was looking at Jeffrey Williams, Your Honor. I apologize.
All right.
Anthony Williams.
All right. State your appearance, please.
Jesse Green, Special Assistant Attorney General, here on behalf of the people, Your Honor.
He's in custody.
Yes, Your Honor, we're planning on waiving the preliminary exam. I actually didn't sign the form.
No objection, Your Honor.
Anthony Williams.
All right. He's waiving preliminary examination.
Yes, Your Honor.
Sir, is that a correct statement?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also do waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over on a single count.
We acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
September 30th at 1:30 with Judge Cummings.
September 30th, 2025, 1:30 before Judge Combs. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the people versus Rayshawn Dawson.
Morning, Your Honor. Morning, Your Honor. Sam Bernstein with and on behalf of Mr. Dawson. Mr. Dawson, could you please state your name to the court?
Rayshawn Dawson. Thank you.
Your Honor, we're asking for an adjournment, please, to review discovery.
Without objection, probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls the case People versus Douglas Brown.
Good morning, Your Honor. Michael Vincent on behalf of Douglas Brown. Mr. Brown, state your name.
Douglas Steele Brown, Your Honor. Excuse me. Good morning.
Good morning.
Your Honor, this is a day probable cause conference, and I'm going to request an adjournment. We still have discovery to get.
Well, where's your? Okay. Yeah, exactly. I lost you there and I said, I'm not asking Vincent. Well, October 9th work. All right.
Thank you, Your Honor.
Probable cause conference will be adjourned October 9th, 2025, 9 a.m. Bond will continue. Thank you. Court calls the case People versus Terrence Ginyard.
Jesse Green, Special Assistant Attorney General, here on behalf of the people, Your Honor.
Thank you.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Ginyard. Mr. Ginyard, can you please state your name for the record?
Terrence Ginyard. Go ahead.
And Your Honor, I am asking for an adjournment today. I have reached out to AAG Williams on this matter. I wasn't aware that a different AG might be covering today's case. So I am just seeking an offer from them. I did just get good contact information from my client as well. So I'm just seeking a 2 to 3 week adjournment.
Without objection, I'll adjourn this to October 9th, 2025, 9 a.m.
Your Honor, may I ask that we schedule for something after the 10th? We're concerned about a government shutdown, which would mean we wouldn't be able to appear for hearings.
Hold it. That state government shutdown?
Yes, Your Honor.
Hold on a second.
Unfortunately.
But I'm a county.
I know you are, Your Honor, but.
No, I was just looking for time off. I'm just.
They wouldn't.
So you need something after the 10th, you believe?
Yes, Your Honor. Thank you.
So, well, he's out of custody. I'll tell you what, because I don't know what that means. I maybe have to read up on that. Let me go to October 23rd.
23rd. Thank you, Your Honor.
Yeah, all right. October 23rd, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Who else? Your county?
Location, date, time. Oh, you need to be here next. Okay. And I will reach out with your new number as soon as I can.
All right. Thank you.
All right, take care.
Yes, go ahead. Court calls the case People versus Quentin Coleman Ebersol.
Good morning, Rachel Nelson, the prosecuting attorney on behalf.
Your Honor, good morning. Joe Simon on behalf of Mr. Ebersol. State your name, please.
Quentin Coleman Ebersol. All right, I have before me a plea form. That's what we're doing.
Yes, Your Honor.
Indicating that he's going to plead no contest to 3 charges. First charge is count 3 larceny 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration. Also, intentionally dissemination, of sexually explicit visual material, 93-day misdemeanor, and count 5 of domestic violence, also a 93-day misdemeanor. Upon his successful plea to those 3 charges, counts 1 and 2 would be dismissed. There is an agreement that sentencing to be determined by probation, and that's the court's full understanding of the agreement. Is that correct?
That's correct.
Your Honor, that my client's ready to enter those pleas. Because he was in custody, I read to him all of the forms and he authorized me to sign on his behalf, and I reviewed them again with him this morning.
All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and the truth so help you God?
Yes, I do.
State your name.
Speak up a little louder.
Quentin, 20 years old.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to 3 charges. Is that correct?
Yes, Your Honor.
All right. The first charge is count 3 of larceny 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, Your Honor.
Also, then count 4, which is the dissemination of sexually explicit visual material. That is a misdemeanor punishable by up to 93 days in jail, a $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
And also then count 5, the charge of domestic violence. That's a misdemeanor punishable also by 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it. I have to make sure that you understand it. First means that you're not further desirous or wanting to contest these 3 charges. You understand that?
Yes, Your Honor.
The second thing is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge. And you would be sentenced by Judge Freshour in the 14A4 District Court.
Yes, Your Honor.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. Sir, to the charge of larceny 200 to 1,000, how do you plead?
No contest.
To the charge of intentional dissemination of sexually explicit material, how do you plead?
No contest.
To the charge of domestic violence, how do you plead?
No contest.
Do you understand that by pleading no contest, you will not have a trial of any kind?
Yes, Your Honor.
All right. You went through an advice of rights form and had your counsel sign that on your behalf. Is that correct?
Yes, Your Honor.
Do you have any questions regarding any of the rights on that form?
No, Your Honor.
There's a copy on the podium. Please look at paragraph 5. You understand that because you're not having a trial, you're giving up those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal outright.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
The court has been provided and has reviewed Michigan Department of State Police report for their case number 5269-25. Any objection to the court having reviewed that report?
No objection from people, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the guilt of the defendant with reference to these 3 charges. Sir, I do have to advise you that if you commit misconduct as defined by the Michigan court rules between the time of the acceptance of my plea and the time of sentencing, that you would not be entitled to withdraw your plea, and the court would not be bound by any sentence recommendation. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or inducements that have led to this plea?
People are not, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's pleas of no contest to counts 3, 4, and 5. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
September 25th at 10:30 a.m.
September 25th, 2025, 10 a.m. before Judge Rush Hour.
Your Honor, may I address bond? And with that hurried date, I'm telling my client, I didn't mean to take a minute to talk one thing. About just over 3 weeks ago, Your Honor, my client turned himself in on the court, revoked his bond. He had a $25,000 10% bond originally. He admitted violating his bond by placing his call to his former spouse, estranged spouse. And she contacted the authorities, and obviously that's how he's in. I'm asking the court to consider reinstating that bond. The amount of time he served is pretty substantial, but he knows he earned it. He wants to get back to work. And he was on a GPS tether before, and he certainly would wait to be tethered again if released.
Response.
Your Honor, discretion. I will say people are very concerned about the behavior of this defendant, not only as the basis for the offense itself, but then violating it after the offense occurred and after he was specifically told what the conditions were. This is a situation where we have no, I think it's best left up to the PSIR. We would be more comfortable with staying in custody until the court has been done. And then, of course, they can make that determination and recommendation to the court. But at this stage, there are too many concerns and they're adding up to be an unsafe situation for this victim.
I'm going to deny your request to change his bond once certainly the pre-sentence investigation is done and you got a relatively quick sentencing date, so the Judge Fresh Hour can make that decision. At this time, but motion for bond reduction is denied.
And I apologize, Your Honor, the court will make we have a change in address. Was that made already, or should we approach it?
Change in address of.
For the no contact.
That should be communicated directly to community corrections. Well, actually, we're going to have the no contact. If that can be provided in writing, we'll make sure that the file is updated. Thank you. Court does call the case People versus Imbe. Is it Indicate? Imbe.
Good morning, Your Honor. Assistant Public Defender Daphne Leba for Mr. Ndie.
Yeah. Jesse Green, Special Assistant Attorney General on behalf of the people, Your Honor.
All right. He's waiving preliminary examination.
Yes, sir. He has executed waiver form, which I provided to the court.
Sir, is that correct? You're waiving preliminary examination?
Correct.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Right.
You understand that?
Yes.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
People also waive their rights.
Yes, Your Honor.
And Your Honor, I do just want to put on the record that we're waiving with an agreement of an offer available with a delayed sentence.
That's correct, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on both counts.
Thank you, Your Honor. We acknowledge receipt of the information and waive formal reading. Enter plea of mute at this time.
Defendant having waived formal reading standing mute, the court will enter a not guilty plea. Pretrial will be set for
November 6th at 1:30 with Judge Slay.
November 6, 2025, 1:30, Judge Slay.
Thank you, Your Honor.
Bond continued. Thank you.
Thank you, Your Honor. Have a great day.
You do the same, sir. Court does call the case of the People versus Dwayne Stevenson.
Good morning, Your Honor.
David I. Goldstein, appearing on behalf of the defendant.
Your name, sir?
Dwayne Stevenson.
Thank you.
Your Honor, I believe I have all of the preliminary, discovery in this matter. We ask the matter be set for a preliminary examination.
People have their witnesses available the 30th.
I'll be right back, Your Honor.
All right. Preliminary examination. We said September 30th, 2025. At the 12 noon, that's before me.
I'm sorry, did you say 12 noon, Your Honor?
Yes, sir. Bond will continue. Thank you. Court does call the case of the people versus Abdel Motion Osman. People versus.
And good morning, Your Honor. Brandon Bird on behalf of Abdel Mosen Osman.
And ask about this with people in both cases.
Brown, case 25 F2 1031.
Your name, sir? Osman. All right. What are we doing?
Examination. Set preliminary examination and.
Is discovery complete?
Yes, Your Honor.
Mr. Bird, what do you wish to do?
Please, to set the preliminary examination, Your Honor.
Discovery is complete on your case?
As far as I know, Your Honor.
People have their witnesses available on the 30th?
There are 2 possible go one more week.
Any objection from either side on that?
No, Your Honor.
No, Your Honor, that would be the 6th.
That, I think it would be the 7th. Will that work?
It'll work, Your Honor. Thank you.
Preliminary examination in both these matters will be in person October 7th, 2025, 9 a.m. before Judge Freshour.
Thank you.
Thank you.
Right, thank you. Bond will continue. Thank you. Court does call the case People versus Emmanuel Hunt. That one I see.
Yeah, no, I got it.
Mr. Bird, you want to state your appearance?
Sorry, Your Honor. Yes, Your Honor. Good morning again. Brandon Bird on behalf of Emmanuel Hunt. Mr. Hunt, can you please state your full name for the record?
Emmanuel Julius Hunt.
All right, what are we doing in this case?
Respectfully, Your Honor, I would like to ask for adjournment in this matter just to get all the discovery. Actually, I just got all the discovery yesterday, but we have a chance to go over it and go over with my client.
All right.
Your Honor, no objection to the adjournment. If there's any discovery that's outstanding, feel free to contact our office and I'll make sure you get everything.
All right.
There's also another matter, Your Honor.
Yes, I have 1 in 3 weeks, counsel, which would you, well, I have the 30th. I can set it for that date. Will that work for you?
The 30th will work. The 30th will work, Your Honor.
All right.
Thank you.
Probable cause conference will then be adjourned. This is a Tuesday, September 30th, 2025, 9 a.m. Yes.
Your Honor,
Thank you, Your Honor.
Hang on. Go ahead.
Your Honor, I received information that this defendant has made, as of when we last checked, 19 calls to the victim. I'm sorry, since being arraigned, 19 calls at her listed phone number from his kin as well as other inmates' kin. And the communication is quite varied. There are a lot of calls. There are several concerning statements, though, regarding getting on her about why she's not getting out, talking about that this needs to go away and so on and so forth. And I'll make sure I share all of that with defense counsel. However, at this point, we would ask that his phone privileges be revoked. And if he wishes to have a hearing, need a bond violation hearing.
Your Honor, we could definitely address the bond hearing on September 30th, but I haven't received any of these phone calls or any of this information to be able to have a valid argument against the prosecution at this point. So I respectfully ask to keep his bond the same until I have the evidence in front of me and I'm able to be on equal ground.
If you wish to have a hearing, certainly the court will grant you that. But at this time, based upon the representation I'm going to revoke the defendant's phone privileges. His bond and all other aspects will continue. And then we'll see you on the 30th. Thank you.
Thank you, Your Honor.
The court does call the case of the people versus Gabriel Shawaka.
Good morning, Your Honor. Tina Sachs on behalf of Mr. Shawaka.
Your name, sir?
Gabriel Shawaka.
Thank you. What are we doing?
Your Honor, I'm asking for a preliminary exam date, please.
All discovery is complete.
To my knowledge, it is.
People have their witnesses available on the 30th. Preliminary examination in person will be set September 30th, 2025, 9 a.m. That is before Judge Wash. Bond will continue. Thank you.
Thank you. Thank you, Your Honor.
Court does call the cases of the people versus Annie Oglesby.
But the next one, I'll be first.
I'm waiting to see the picture from yours, but I think I know somebody that's on this. Yeah, so I'm gonna try and call them up and see what's going on with that. I say, Shamar, no, Shamar, maybe here. I say somebody.
Okay. I don't have an order on the 15th District Court case. I do have obviously one on the other case. But.
Okay. All right, then. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Oglesby.
Hi.
Can you state your name?
And Annie Oglesby.
All right. Thank you. All right. I have all counsel here for the record. All right. What are we doing?
So, Your Honor, today is the date and time set for a probable cause conference. I do believe that our office has discovered a conflict in our representation, and we will be moving to withdrawal. So we may need to have an adjournment of this matter for that case.
All right. Saxon, on the one that you are on, what do you wish to do on that case?
Your Honor, we're asking that to be set for a preliminary exam.
All discovery is complete on that case.
The judges.
Yeah, I believe it is, Your Honor. Yes, I do believe it is, Your Honor. I have all video.
People have their witnesses available on the 30th.
Try, Your Honor. Thank you.
Preliminary examination, that is in case 1022. Preliminary examination will be set in person for September 30th, 2025 at 12 noon. That's before me. Bond on that case will continue. On the other case.
Anna, what is my client's bond set at in the?
Pardon?
What is my client's or current client's bond set at in the 5753 case?
And it's a 1,000 cash or surety in that case. In the case before you, or that's your office is still on. In the other matter, I don't have an idea. Oh, in the case, because it looks like because of a bond violation, her bond is denied on.
Okay.
Your Honor, I'd like to make a bond motion in regards to that.
Hang on. In your case, Mr. Brown, I'll adjourn the probable cause. I'll just go 1 week out to 25th.
Thank you.
September 25th, 2025. 9 a.m. Well, actually, why don't I just go ahead? I'll just do it the 25th. And I'm presuming you're going to want to change the bond if there's a change in the other's bond. Go ahead, Ms. Saxon.
Your Honor, we understand the bond was revoked because Ms. Oglesby failed to test. She has arranged for to stay in Ypsilanti and be able to test She'll be closer than she was living before. So I'm asking for a nominal bond to be set so she can go back to work, get reunited with her children, but also show that she is able to comply with the testing this time.
And for the record, Your Honor, my client has the same issues in this particular case. She would make a likewise request for a nominal bond.
But she is, was she already in, well, but she didn't do anything in regard to the testing. She just didn't do not a thing.
When she got released, she went back to Jackson. She did not have transportation, or more importantly, she didn't have the money to pay. She has now made provision so that she can stay with her in-laws in Ypsilanti. Therefore, it would be easier.
I gave her 2 times to get this done, it looks like.
The first time, Your Honor,
I was incarcerated. Go ahead.
The first time, Your Honor, she was incarcerated in another county, and there was just a miscommunication. They did not know she was there, so she could not comply the first time.
Right. So when she came down, I said, then you need to go to testing, and she didn't do it.
I think that was a transportation issue.
Yes.
She did say that she would call and was unsuccessful and they would get anything done that way.
Motion for bond reduction is denied. I'll reconsider it at the time of her exam, but at this point, I'm going to deny the motion. On both cases, the bond will continue in both matters.
Thank you.
Thank you, Your Honor.
Court does call the case of People versus Taylor Adams.
Ashley Feltus for the people.
Assistant Public Defender Jay Bell on behalf of Mr. Adams, who approaches. Mr. Adams, can you please state your name for the record?
Taylor Adams.
He's waiving.
He is waiving, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
Do you understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following. Mr. Bell.
Your Honor, we acknowledge receipt of information. Wait formal reading, stand mute at this time.
Defendant every way formal reading standing mute. Court will enter a not guilty plea as to both counts. Pretrial will be set for
November 18th at 1:30 with Judge County.
November 18th, 2025, 1:30 Judge County.
Thank you, Your Honor.
Bond continued. Thank you,
Your Honor.
Go.
She needs to sign.
We'll be in touch.
Court does call the case of People versus Taiwan felon.
Ashley Feltus for the people.
David I. Goldstein appearing on behalf of the defendant.
Taiwan Baylor.
Your Honor, we've had some preliminary discussions with regard to potential resolution in this matter. However, the person I need to speak to is Mr. Ganatra, and he's not available at this time. So we're going to be asking for a 1-week adjournment. If that's acceptable to the court.
Probably not, but what the heck. Probable cause conference will be adjourned September 25th, 2025. 9 a.m. Bond continues.
Your Honor, I would like to address the court on the issue of bond. I did alert Ms. Phelps, and if I call her Landy, I apologize. But anyway, Your Honor, my client in this matter is charged with 3 counts. One is a maximum of 10. The other 2 are maximums of 5. They are nonviolent crimes. To my knowledge, my client.
Most people think missing court is no big deal until a judge proves otherwise. In this courtroom, Roger Peterson never shows up for his scheduled hearing. The judge checks the time, confirms that nearly 10 minutes have passed, and even notes that the courthouse security cameras show no sign of him entering the building. From the court's perspective, there is simply no excuse for the absence. The prosecutor asks the court to issue a warrant, and the judge agrees. But she doesn't stop there. Instead of a $500 cash warrant, she raises it to $1,000 cash, making it clear that failing to appear has serious consequences. Then comes another costly mistake. Because Peterson failed to appear, the judge finds him in default on 2 traffic-related cases. One results in a $200.50 assessment and 3 points on his driver's license, while the second adds another $263.50 in penalties. Both amounts must be paid within 30 days, and he won't receive a new court date until the cash bond is posted. It's a powerful reminder that ignoring a court date rarely makes a case disappear. In fact, it often makes the situation much worse, leading to larger financial penalties, warrants, and additional legal trouble that could have been avoided by simply showing